going to introduce our speakers in a moment. One of our speakers had to step out. I am not Charlie Shaner, and that's unfortunate for you. Neither is smart or is good looking. Unfortunately, he had an emergency that he had to attend to, and I was asked to stand in, and I will do that. Actually, everyone's here now, so I'm going to go ahead and introduce our panel today, and then we'll get into the topic of it. We're really lucky to have this particular panel because the individuals here are folks that have a special expertise in the area we're going to be talking about, which is Twombly and Iqbal. Our first participant today is Suzette Malvo, who is an associate professor of law at Catholic University, and she was also a professor at the University of Alabama. She regularly provides commentary on various constitutional legal issues involving the Supreme Court, and you may have seen her on CNN, MS, NBC, and BET News, as well as Fox News Channel 5. She has written a case book on class actions and multi-party litigation, and in your package that you have outside, you will see an issue brief which she has prepared, which you will discuss some, I'm sure, today. She's appeared before the U.S. Supreme Court and the 11th Circuit. She's a graduate of Harvard University, magna cum laude, and got a J.D. from NYU University, where she was associate editor of the Law Review. The next down is John Vale, who is Vice President and Senior Litigation Counsel for the Center for Constitutional Litigation. He represents clients in litigation challenging restrictions on the constitutional rights of access to justice, which is, of course, the topic of this presentation today. He represents the American Association for Justice on constitutional matters and advises legislative advocates regarding pending legislation. He was one of the filed an amicus brief in connection with a Concepcion case argued this week in the Supreme Court dealing with arbitration and unconscionability clauses. Mr. Vale is a professorial lecturer of law at George Washington University, and he's a graduate of the College of at the University of Chicago and law school at Vanderbilt. And far end is Josh Sivan, who is Assistant Counsel to the NAACP Legal Defense Fund, the LDF. He clerked for Justice Ruth Bader Ginsburg and also, I believe, for Judge Reinhardt, is that correct, of the U.S. Court of Appeals for the Ninth Circuit?
Reinhardt, not Rehnquist.
I was about to say, I saw that and I said, I meant Reinhardt, not Rehnquist. That would be an interesting dichotomy, wouldn't it, for that? He graduated summa cum laude from Yale University, studied history at Oxford University as a Rhodes Scholar, and received a J.D. from Yale University. He also filed a amicus brief in the Concepcion case, and there's an issue brief which he's prepared relating to the topic that's in your materials, which you may want to see. Their bios go on much longer than what I have said. It's in your materials. Mine wasn't very important, so they didn't put it in there. So actually, I'm J. Elmore with Bond, Wright, Mixon, and Elmore in Atlanta. We do a lot of civil rights work. I personally do a lot of class action litigation around the country and have been involved with a number of matters involving the issue that we're going to talk about today. And that issue is the Twombly and Iqbal decisions of the Supreme Court. How many in here are lawyers? Okay, so we've got a number of folks that are not lawyers, so therefore I'm going to back up and do a 30,000-foot look at this issue, what we're talking about. In the civil procedure, when a case is filed, the plaintiff files his complaint, and the defense may file a motion to dismiss. And as a very simple context, let me say what this would be is that that you can't state a claim of action under these facts. And that might be someone would sue me and say, I'm suing you because you didn't invite me to your Halloween party. And I would respond to that by filing a motion to dismiss, saying, that's correct, I didn't, but I didn't have to. Later on in the proceedings, at that point in time, there is no discovery, other than what the individual may happen to have himself, the plaintiff. Later on in the civil procedure, there's another process before the trial called a summary judgment. At that point in time, the parties have had a lot of discovery, and they can therefore put the facts before the court. At the pleading stage, the motion to dismiss, they don't have the facts developed from the other side. They haven't had discovery. So that's what we're talking about. The complaint has been filed. Someone has filed a motion to dismiss. And the court is looking as to whether or not there's a legal, what's the legal standard here for determining whether the case will be dismissed. Previously to Twombly, the rule had generally been if there's any set of facts under which the plaintiff could prevail, then it goes forward. And it was a very high standard. I mean, in the context, most cases would get by it. However, the Twombly case involved a matter involving the Sherman Act Section 1 antitrust case. In that, under Section 1, it says, no contract, conspiracy, or combination, and restraint of trade, you can't have that. So the plaintiff contended that some of the Baby Bells had conspired together to kind of set prices because all the prices were the same. And they but they didn't have all the facts about, did they really do this? Was there really a contract between them to do it? And so the Supreme Court looked at it and said, well, what you've said is maybe conscious parallelism in your pricing, which we've said is not illegal, and you haven't alleged or shown that there was an actual contract there that would be illegal. And so they set a new standard, what we refer to as the plausibility. In other words, you must set forth facts from which it is plausible that there will be a cause of action, which is different than the old rule that had lasted for several decades, that any set of facts would be sufficient. I mean, any possible facts there. Many of us thought, and I do some antitrust work, thought that perhaps this was just limited to antitrust field because there are peculiar rules relating to antitrust. But then later in the case of Iqbal, we found that no, this is going to be sort of universal in civil cases. And Iqbal, without getting too deeply in the facts, involved a Pakistani who had been detained and removed from the general prison population and put into more maximum security. And he claimed that his constitutional rights had been violated, they'd been mistreated, et cetera. But he sued some fairly senior people in the administration, and he couldn't plead specific facts about their knowledge of it or participation in it, and therefore the Supreme Court said, well, under the plausibility standards of Twombly, you lose. You're out. You're kicked out. Justice Souter, who had written the opinion, and Twombly said, no, you misunderstand. But the majority said, nope, we're applying it, and this is how it works. Since that time, there's been a lot of ink spilled by district courts and courts of appeals trying to come to grips with what this means, what this new standard and new rule is. What we're going to address today is you're probably already beginning to pick up on this. In the civil rights context where someone makes an allegation before discovery, can they plead the facts? Does it have an impact upon civil rights cases that may be disparate as even more so than any other civil case? And so our panel here have written articles on it. They've got an issue paper. They've been very much involved with it, and I'm honored to be able to be here with them. I'm going to start out with a very quick question and let each of the panel members talk about it, and then we'll get a little bit more in depth. I'm going to try to reserve some time at the end for you to have questions about this, because I think you're going to find out, though, while on its face it seems to be a very technical issue of pleading, in fact, it may have a determination as to whether the courthouse door is slammed before people even get there. And And my first question is, in a nutshell, what changes have you seen since Iqbal and Twombly, and what do you think about those two decisions?
What issues are there?
Yeah, right. In other words, what is it that you see about Iqbal and Twombly that you think have a specific impact in the civil rights cases?
Well, I talk about, you want to take that? I'll talk about a little broader context of it. You want me to do that first, or you want to talk about civil rights cases first?
I'll be happy to start off.
I knew you would.
To back up a bit, Justice Ginsburg, after she dissented in Iqbal with Justice Souter, told a group of judges that Iqbal and Twombly had messed up the rules of civil procedure. And she must be right because she was my former boss, but this is all very technical stuff, and I think that the question is, why, as civil rights lawyers, as civil rights advocates, do we care about the civil rules being messed up? And I think that really it's not an overstatement to say that many of the key successes of the civil rights movement and the civil rights litigation that brought about a lot of the successes in the last half century are due at least in part to the old liberal pleading standard. And I mean liberal not in terms of left or right, but liberal in terms of permissive and allowing people access to courts. Much of our nation's progress really depends on ordinary people having ready access to the courts to litigate meritorious but often novel or difficult to prove cases. People here may probably know some of these names, but the broader American public doesn't know about Heman Sweat or Pete Hernandez or Ann Harper or Mildred and Richard Loving or Willie Griggs. But these folks were able to go to court, and their ability to do so literally changed our understanding of all sorts of issues like access to justice, like jury service, access to the voting booth, marriage, and equal employment opportunity. And they were able to do so because the federal rules back in 1938 really put into place a very permissive open standard for getting into court. What you needed to do is file a short, plain statement showing you were entitled to relief. And in 1957, in a civil rights case, the Supreme Court put its stamp on this and said, in a case involving African-American railway workers called Conley versus Gibson, these African-American railway workers had sued their union for violating its duty of fair representation. Basically, the union and the employer, the railroad, had effectuated a scheme where the black workers were all dismissed and white workers were hired in their place, and the union didn't do anything about it. The union came in and said they didn't file a complaint that showed entitlement to relief, and the Supreme Court unanimously rejected that argument and really affirmed that the purpose of the federal rules is to eliminate procedural traps, to eliminate gamesmanship, and facilitate a decision on the merits of a claim, to get to what was really the core of the litigation. And this rule flourished and allowed all sorts of access to court cases and access to court to litigate important issues. And really never was questioned by the Supreme Court until about 3 years ago, it's 3 years ago now in Twombly, Craxton Foundation in an antitrust case, and everybody sort of thought, well, maybe that's just antitrust. But no, in another civil rights case relating to 9/11 and the government's policies after 9/11, the court put into place this new plausibility standard. And this standard has a lot of problems, and I can go, one of them that I'll just focus on here and then turn over to my other panelists, is that you're supposed to determine plausibility based on judicial experience and common sense. Now, that standard, as Judge Shara Scheindlin from the Southern District of New York said, is a frightening thought. Because when you look at judicial experience and common sense, not to say that those aren't important, and the judges in the room, no disrespect at all, judicial common sense and experience are very important, but looking at just the bare bones of the complaint, often a judge or any person looking at a complaint is going to be processing based on their own preconceptions and opinions. And Iqbal itself highlights the examples of this. The Second Circuit majority and the 4 dissenting justices thought that the crisis triggered by 9/11 made it plausible that top government officials like Ashcroft and FBI Director Mueller, that they had condoned a discriminatory policy of mass arrests of people based on their race and their religion. By contrast, the Supreme Court majority thought that legitimate law enforcement policies and principles made it more likely that, notwithstanding the cautionary history of the Japanese internment after World War II and the Supreme Court's endorsement of that in Korematsu, notwithstanding all that, that it was more likely that legitimate law enforcement principles were at stake. A difference based on judges and their preconceptions. Going to our own history, LDF litigated one of its landmark cases, school desegregation cases, Swan versus Charlotte Mecklenburg, school desegregation case, shows the examples of judges' preconceptions pretty well. The judge who ruled on that and ultimately issued an order requiring stringent and robust desegregation of the schools in Charlotte Mecklenburg recognized that when he started the case, he didn't really appreciate what was at stake. And let me just quote him because I think it's important to get this sense. He said, "The case was difficult. The first and greatest hurdle was the district court. The judge, who was raised on a cotton farm, which had been tended by slave labor in his grandfather's time, started the case with the uninformed assumption that no active segregation was being practiced in Charlotte Mecklenburg schools, that the aims of the suit were extreme and unreasonable, and that a little bit of a push was all that the Constitution required of the court. But then he said that after listening to the evidence presented by the plaintiffs, they produced a reversal in the original attitude of the district courts." So it's this idea that judicial experience tempered by the facts and the opportunity to develop the facts through discovery is critical to allowing victims of discrimination, allowing people who have experienced civil rights violations, the opportunity to challenge the preconceptions of judges, like the judge in that case, and the broader public. History is really full of implausible events, and some of the most egregious civil rights violations, especially in today's world, are often some of the most implausible. And I'll just give an example of that and then stop and turn it over. That one example is, in one of our recent cases, led to the exoneration of nearly 10% of the black community in Tulia, Texas, who were arrested in a drug sting. But it came to light that they were all arrested based on the uncorroborated evidence of a single DEA agent, DEA-funded agent, who turned out to have a very checkered history of misconduct, legal violations. But based on his evidence, these folks all went to jail, and it took a long investigation to bring to light the facts that were critical to exonerating them. Those facts and that type of development is what's at issue here and what's at issue in making out a case and establishing civil rights violations. Another issue, and I'll do this as a lead-in for Suzette, that's critical and really important is the issue of what's called in the technical world of legal cases, information asymmetry.
Thanks. And I will sort of focus on that as well. I just wanted to step back for a moment and say that I really think that this is an important issue, and that sometimes we don't realize that procedural issues are civil rights issues, right? We think about justice, and the first things, it just doesn't come to mind when you think about that. So you might see things, voting rights, you might think education, you might think criminal justice, and all of those issues are very important, but sometimes there's a real disconnect, and we don't think procedure, that actually is a civil rights issue. And I can tell you just from experience, I guess it was a couple months ago, I was on a panel, the National People of Color Legal Scholarship Conference occurred, and the theme was a post-racial theme. And so everybody was on panels and sort of traditional kind of civil rights topics. And, there were 4 of us that were on the panel, and we had this ongoing joke, how many people, do you think there are going to be more people in the audience that are on the dais, right? And we weren't sure if that, because people are not recognizing that connection. I will say there were 4 on the panel, and there were 5 in the audience. So, we met our goal. But and in all fairness, there were about a dozen other concurrent sessions, and so our topic wasn't probably the sexiest. But I think it was really important for people to make that connection. And so I love the fact that we're having this conference, because we're going to be dealing with arbitration, class actions, and now pleadings. They all are actually civil rights issues, even if we don't realize that initially. For the students here, I think we hear sometimes your professors will say that the rules are transsubstantive. Like, what in the world does that mean? Basically, we think the rules are supposed to apply equally across the board, no matter what your cause of action, what the underlying substantive claim is. So if it's a civil rights claim, antitrust, contracts, any of those, then the rules should be equally applied. But what's happening now is, after Twombly and after Iqbal, the way the Supreme Court has interpreted the rules, 12b6, motion to dismiss, or Rule 8, what goes into a complaint, it has a disparate impact or a negative impact on civil rights cases, and so other types of cases are vulnerable to that more rigorous pleading standard. And so we have a sort of a new problem here. As Jay mentioned, we go from this, some of the problems, why it is that civil rights cases are more vulnerable. We go from, first of all, the bar has been raised, and now you have to have facts not only that show a possibility, but a plausibility that your claim is legitimate. And so we have moved in that direction. Before, if you had a civil rights claim, your facts could show that maybe they're consistent with legal and illegal behavior, right? Which is what we would expect to find. Early in the litigation, nobody's had any discovery. So, the facts may show that a female was denied a job because of gender discrimination, or the facts could show that she was denied a job because of some legitimate criteria, like maybe she didn't have sufficient qualifications. But at the early stage of the litigation, we have no idea, right? And those facts are going to indicate two entirely different theories. The problem now is that's no longer acceptable. If you have your set of facts, it's not good enough to have your facts consistent with these 2 alternative theories. Your facts have to plausibly show the illegal conduct rather than just show that possibility. And you can imagine for civil rights cases, it would be normal early in the litigation that you have alternative theories, right? That the facts are going to point to 2 different directions until we can really get into discovery. So that certainly is a problem. As Josh mentioned, I think the subjectivity is a real issue. You can imagine 2 different judges, same set of facts, and they have to determine, which one is more plausible. And again, if you look at some of the data coming out, there's a big debate over whether or not we're in a post-racial society, right? A lot of people have had these kinds of conversations. Some folks will say, discrimination is no longer, that's not a big problem, right? That's over, that's sort of water under the bridge, we're tired of hearing about it. So you may have folks that are of that mind, and then you have others that realize discrimination is still alive and well, is still an issue. Without some kind of guidance, right, a real objective standard, then you're sort of leaving this determination of what's plausible. Is discrimination a plausible theory, or does something else more likely to explain these facts? You're leaving that open to just sort of the subjectivity of the particular judge, and we want to have objective standards to the extent that we can, so that we have predictability and lack of confusion. And then the other real problem, which Josh had alluded to, I think is very problematic here, is that it's difficult for plaintiffs to unearth information, those facts that they need to show that they have a plausible claim, if they don't have access to discovery. So you can imagine an intentional discrimination case, or you're talking about policies, procedures by an employer. You know, first of all, it's difficult to get at intentional discrimination because we know it can be subtle and institutionalized, and so that's hard. But also, the plaintiffs don't have the same access to information that the defendants do, so they can't get those facts that are necessary to show intent. So examples, you think about, say you bring a Section 1983 police brutality case, and you know you've been beaten up by the police, but you have no idea the identity of the particular officer, right? Clearly, the defendant has that information, the plaintiff doesn't, right? So that's an example of informational asymmetry or inequality between the parties. You think about the Lilly Ledbetter example is a good case here, where she had no idea that she had been paid less than her male counterparts for years and years and years. That information wasn't made available to her. Obviously, the employer had that information. And of course, she ended up filing her case way after the statute of limitations had expired as a result of that. So again, that informational asymmetry. And the plaintiffs are really in a catch-22, I think, now, following Iqbal, because what they're being told is, you need to have enough facts to push your complaint over from possible to plausible, right? And the plaintiff can only get those facts in discovery. But the judge doesn't let you get to discovery because you don't have the very facts that discovery would enable you to survive the dismissal. So they're really stuck in a bind here in terms of where do we go from here. And we're starting to see, as a result, civil rights cases being dismissed, potentially meritorious cases being dismissed. The data indicates that they're, at least the initial data indicates, it's a little bit mixed, but the initial data seems to indicate this, which really brings into to the forefront the risk of under-enforcement of civil rights and really not having access to the courts. So we'll probably be talking about some of the potential solutions, ways we might address that.
So I'll yap for a minute or two. Who here thinks this is a debate about pleading, this Iqbal and Twombly stuff? Yeah, nobody does. Yeah, it is a smart crowd. This debate doesn't have anything to do with pleading. This debate happens because the powerful are annoyed that that persons without powerful get to annoy them too much through the system. That's why this debate occurs. This is a debate about allocations of power. And it's a little funny for us because when we think of civil rights or civil liberties, we often tend to think of powers against the state. And this doesn't involve just litigation against the state or state actors, although it certainly does that, but it also involves litigation against private actors. It doesn't fit well into our usual constitutional paradigms. So one of the things that I wanted to tell you, to remind you, because you know this intuitively if you don't know it in the case law, is that access to courts is one of the most fundamental things of fundamental importance to the functioning of our democracy. It's what the petition clause in the First Amendment is about. And it's the subject of Marbury versus Madison, in which Justice Marshall writes that one of the first duties of a civilized government is to provide remedies to its citizens who are aggrieved. And that's remedies for both private wrongs and public wrongs. So we usually think about constitutional rights. This comes to us as a duty of the state to open up and provide these dispute resolution mechanisms. What's happening now? With modern pleading, it's got a lot easier to get into court than it was, say, in the 19th century. And when we enacted the federal rules in 1938, we thought that was a good idea. We got rid of a lot of formalities. We said, the courthouse door is wide open. Come on in. And let's see what you've got. And then, once you're in the courthouse, the question then is, how much do you have to show in order to get subpoena power, in order to get the state on your side to make the person on the other side of the V in the complaint respond to you, to use a little force? And that's the duty of the state, is to provide that little bit of force, that little bit of compulsory process to aggrieved persons, to keep those grievances from going greater and undermining the whole democratic idea. So what's going on here now? Extant in this debate, after Iqbal and Twombly, there are big debates about what to do next, what to do with pleading, all right? Let me say that I think there's almost nobody who really cares about pleading. They care about discovery and liability. Pleading is just a proxy. And there are two camps right now lining up on what I'll say is the other side of this debate. There's one side that says that pleading not only should be Iqbal Twombly, but it should be more fact-bound, more formal, that we should return to requiring the pleading of material facts, the pleading of ultimate facts. Is there anybody here who can tell the difference between an ultimate fact and a material fact and a regular old garden variety fact? Because I'm telling you, I can't. I confess that. I cannot. And I think that that's why we adopted the 1938 rules, because people admitted that nobody else could either. But there are huge, detailed, serious proposals extant out there to do that things. Now, for the camp that pushes those proposals, I propose that they take their waistcoats, grab their cigars, have their glasses of port, repair to their drawing rooms, and discuss those things, and leave the rest of us alone. Right? Because that should not come back. It is a ridiculous debate. It is ridiculous to talk about this issue in terms of pleadings and what you put on a paper. In all of these cases I've read, cases that have been dismissed, cases that have not been dismissed, I think could have been dealt with very readily by bringing the parties before a judge and saying, here's a plaintiff, here's a defendant. And a judge said, defendant, you filed a motion to dismiss in this case. What don't you understand about this complaint? Do you really not understand why you're being sued? You know, his complaint says race discrimination in employment. Do you not understand? What don't you understand? Tell me. And if there is something, then you say, what do you think? You know, that's what they say over here. Well, about that, what do you think? And they say, well, I think that's stupid, or I think, yeah, I don't know whether Jimmy Smith was in Atlanta on November 10th. I don't know, but there's no way for me to know. They do. Can I ask them? And they say, yeah. Was Jimmy Smith in Atlanta on November 10th? Yeah, he was. Okay, so now we got it. We got it set up. You know, these are, in general, not hard things to understand. The real thing that's going on here, and the debate that, you know, will take place among serious people as the riffraff is washed away, is this question of when is it just to require a defendant to answer compulsory process on the basis of what a plaintiff says. Now, to my own mind, that is not a process that's highly adaptable to rules in general. It seems to me to be extraordinarily difficult to write down all the situations where you would anticipate that happening. And I think we're much better to have a wide open door to the courthouse, as we had under Connolly. There's a big debate about whether Connolly was ever really a standard, but we know the formulation, let's say with that. We have a wide open door to the courthouse, and then we have a judge there that can manage the parties before them and say, look, what do you really care about? And there are long things, there are lots of proposals for limited discovery, et cetera. We'll talk about them more. I'll come back to them, to what's extant out there now and what might actually happen in Congress or the Rules Committee. But I think a judge needs the discretion to say, you want plausibility? This smells bad. I'm gonna let Josh take depositions of Smith, Jones, and Malvo. And then, you still got a gripe, come back, we'll see. But I think it's important to understand that pleading is just a proxy. And it's really about, students, one of the most powerful pieces of advice I ever received about finding truth in litigation is just follow the money. It's the old Woodward and Bernstein thing. It goes a long way.
I think what John he just brought up actually transcends this pleading phase, and we see, I think, the access to our courts being attacked in a variety of different ways, and some of that includes rules trying to the loser pays, restrictions on the attorney's fees that can be awarded in certain cases where they're on behalf of folks and things of this nature. So this seems, if we look at it only in the context of civil rights cases and things, we're kind of being a little narrow on that, because this will also apply to someone in all sorts of your garden variety lawsuits and things of this nature that may have an effect that may be very important to them, which is usually an individual against someone, as John says, with power. Let me ask a couple questions. What sort of empirical evidence do we have, or what have you seen in the context of the application of this that has already bothered you in some of the cases? Have you all had any experience with that would like to comment on it? I mean, one thing is the concept we're talking about. It has the potential. What's the reality that you've seen?
I can tee up one example that comes to mind. Case of Kevin Williams, who was arrested in Cleveland, Ohio, by cops for a robbery and a shooting that happened at a deli. For 8 months, Williams sat in jail, even though there was videotape evidence that he was working at as a janitor about 10 miles away, videotape evidence that clearly established that he wasn't anywhere near the deli where the robbery took place. He finally got out, the video evidence came forward, and he turned around and sued the city of Cleveland and said, my civil rights were violated by this wrongful arrest and wrongful prosecution. District Court throws out the case. They said, yeah, you have some evidence that this happened to you, but you can't show us anything to establish that there was a policy here or a practice here of doing this more broadly. Get out of court, case over. But that evidence of policy or practice, the broader evidence, is quintessentially what you need discovery to show. There's no way, in many cases, that an individual subject to wrongdoing by police or by a corporation or by whomever necessarily is going to be able to go out and find all those other people. So there's often a suggestion in this that what's really being dismissed is bad complaints by lazy lawyers. And I think we need to fight back, because even the best lawyer with the most plush account of resources to be able to use to investigate in advance, even that individual with the best counsel in the world may not be able to work up a complaint that's going to be able to survive, given a case where most of the information is in the sole possession of the defendant.
Let me go a couple of things. Again, the debate, framing the debate. The debate on the other side stems from the premise that a thinly pleaded complaint means a thinly pleaded case. Now, Alex Reiner isn't here today, couldn't be here today, but has done really a brilliantly conceived and executed piece of research that just blows that up. So you just look to Alex's paper and you're done. That premise is wrong. Empirically, there's only a couple of things out there. There's an article by an Oklahoma law professor that shows a disparate impact on civil rights cases. There's, curiously enough, a report from Sherman and Sterling that shows a very significant impact on antitrust cases. But these questions will largely be answered fairly soon. The Civil Rules Advisory Committee will meet on Monday. They have commissioned the Federal Judicial Center, the research arm of the courts, to do an empirical report, and that empirical report will break out civil rights and antitrust cases. And let me say that, a sidebar on advocacy, the only reason it's going to break those out as subcategories is because there were advocates there saying that that needed to happen and showing that it's happened. So you go back to the importance of lawyers, the importance of getting in the way. You know, this is some of the least sexy stuff you can possibly work on, but it's deadly important. But in any case, the materials are out for that Monday meeting. There is not a written preliminary report from the FJC yet, which we were hoping for. Joe Cecil, the principal investigator on that paper, is scheduled to give an oral report on Monday about the status of the research. I will attend those meetings and I will circulate and make available to ACS, you know, any notes or any writings that are available now. But fairly soon, I don't know how much longer it's going to take. We will have a very detailed, careful, and the FJC does good quality research. It will be a reliable document when we get it.
But what we won't be able to measure is all of those complaints that weren't filed because lawyers are out there deciding that because of these cases, they're chilled from even considering a complaint at all, and therefore measuring the civil rights violations that are persisting as a result of this higher standard, that is very difficult to do.
Yeah, and John, if I could share a couple of I think you mentioned the studies. We have some of those statistics here, the Sherman and Sterling report that talked about antitrust. So clearly it's not just civil rights cases, other cases as well, where you have hidden information, conspiracies, things like that, where you wouldn't have access to information before discovery. The study came out, said there was a 65% dismissal rate, has gone up to 68%. If you look at the Patricia Hademeyer study, she looked at the dismissal rate under Conley versus Gibson, Twombly, and then Iqbal, and watched that go up from 46% to 48% to 56%. And there were a couple of other studies related to civil rights. Specifically, there's Kendall Hannon has found where civil rights actions post-Twombly, 40% more likely to be dismissed than other cases. And Joe Siner saw a 2% increase in the dismissal rate of employment discrimination cases after Twombly. So we are starting to see, just even the preliminary data that comes in definitely supports the idea that there's a greater risk of dismissals. Just in addition to the quantitative data, I think qualitatively we're learning from judges themselves who have been on panels, have been sharing the frustration or concerns that they're having, and there are a number of cases where they'll say, if this was Conley versus Gibson, this complaint would have survived. But here, you know, under this new standard, the complaint has to be dismissed. And so that anecdotal information is important to pay attention to as well.
And
And I think that those studies are consistent with some earlier studies about what happened when you have subjectivity in judgment at the summary judgment stage regarding civil rights cases, particularly civil rights employment cases. A good, hard empirical piece by Stuart Schwab from Cornell about that.
And we also have evidence in lots of statements by defense lawyers saying how much they love Iqbal and Twombly. And they're obviously figuring this out and understand, so we should be judging all that evidence in light of those statements. And I just want to add, because it's a great case, that it's not just antitrust cases, it's not just complex cases. There was a recent slip and fall case
Right.
where there was a dismissal of the complaint because the judge said that the plaintiff had failed to allege any facts that showed how the liquid came to be on the floor, whether the defendant knew or should have known of the presence of the liquid, or how the plaintiff's accident occurred. Case out. Now, in this case, the plaintiff, the injured plaintiff, was allowed to replead and repleaded and said it was one of the defendant's employees who had just mopped the floor who caused the accident. And the judge said, okay, pled enough, case can continue. I'll leave it to you to decide whether that was an efficient use of lawyers' resources, of court resources, to add that additional fact in to get the case moving forward. But that's the type of technicalities that we see reemerging here.
From a practitioner's standpoint, I've run into this several times in the federal district courts, and it really depends a great deal on which judge you draw. Some of them are being very difficult, others are not. And part of the problem is some of them are just saying, I don't know what this means, but it's obviously a heightened standard and therefore requiring more pleading and whatever, and almost turning it into a summary judgment before the people can have an opportunity to get the documents on it. I say that we have 10 more minutes because we're trying to get back on schedule. Before I turn any questions over, I was going to see if we can't move into what fixes are available, and at the same time, if you've got some other issues you want to address, go ahead and do it at this time because of our truncated time. What do you think is available to resolve the problems that we've been talking about?
I'll just give one piece of this story that we haven't touched upon, which I think might be important to the dynamic about whether this is fixed and whether it's changed, is courts are increasingly saying that Iqbal and Twombly applies to affirmative defenses. And that, for the corporate defense bar, is a scary thought, because defendants typically plead defenses very, very summarily. They say statute of limitations, or they say contributory negligence, or what have you. And if those defenses are now being required to be pled with particularity and survive a plausibility standing, then maybe there'll be some movement about whether this is such a good thing after all.
I guess there are a number of ideas that have come out, very good ideas, important approaches have been explored. People have talked about a legislative fix, and I will leave it to folks who are knowledgeable in that area to talk about the legislative piece, which is let's roll the clock back to the standard of Conley versus Gibson. There are a number of proposals about changing the federal rules of civil procedure, amending the rules. There's a great article by Arthur Miller that talks about the various ways that you might amend the rules to make this a more equitable situation. And there are lots of ideas that came out of the Duke Law Conference, the Civil Rules Advisory Committee. I think that those, I think the rules change, I think the legislative piece, those are very attractive, and what they offer is institutional change, right? Permanent institutional change. that would go forward. But we know that those solutions may take months, if not years, to come to fruition, if they do, right? We have the politics of trying to get that legislation to go forward, and anybody who's been involved in the rules, changing the federal rules of civil procedure, it does take years. So it seems to me the question is, what do we do now, right? What could we do today to make sure that some of these cases do go forward, and that people are not compromised in terms of having civil rights cases, having that access to justice we were talking about. And this is something John had alluded to, the notion of just having some plausibility discovery, right? Have some very narrow, targeted discovery that goes directly to the question of, does this plaintiff have a plausible claim, or should this survive? And having a judge not rule on the 12b6 motion to dismiss, to defer doing that, and allow the parties to get some really limited discovery on that question. And that is something that can be pushed today in terms of having some of those complaints survive. It is not uncommon for judges to allow discovery on threshold issues early on in the litigation, right? We know that happens when you talk about class certification, jurisdiction, qualified immunity. Those are all occasions where the judge may allow some narrow discovery on this particular issue before we go forward and we get into merits discovery, which is expensive and, time-consuming and things like that. So I think that is possible. I think it's important. I think it's advisable, really, because if you think about the requirement judges have is under Rule 1, you're tasked with interpreting the rules in a way that meets two goals: the justice on the one hand and an efficiency on the other, right? And you got to get that balance right. And I think that would help to kind of get the balance back in order in terms of the justice goal. I get some pushback a little bit on this in terms of, well, are you endorsing a fishing expedition, right? Plaintiff's going to go off and be able to ask all kinds of questions and at the defendant's expense. And so I'm not suggesting that. I do think that the plaintiff's counsel have to continue to do their due diligence, do their homework, before you file a lawsuit. But if you're talking about informational asymmetry, right, you do as the best you can, and at some point, that's all you can do before discovery. You can only put forward so much information because of that informational inequality. So I do think that is an important idea. It's been getting some traction. When I first I was thinking about this about a year ago, and I was consulting with some judges to sort of make sure, did I have this right? I talked to one judge who told me that that's impossible, that's never going to work, right? So I thought, good law review article, right? The other judge I talked to said that it's already happening. So I think that, I'm getting conflicting information here that somehow the idea is somewhere between impossible and obvious, right? And I think it's a modest approach, and I think it's a workable one. I recognize it's not a panacea. It doesn't address the subjectivity we were talking about. It doesn't address all of the problems of the new pleading standard, but it's certainly a good start, and it's a stopgap measure. It's something that can be done now, and given what's at stake in terms of people having access to the courts, I think it's worth encouraging judges to use all of the tools at their disposal to make sure that people do have access to justice.
I'll be very brief because I think we should take a couple of questions with what time we have. So think of those while I yap. Don't listen to me. I've made available to ACS a memo that the Rules Committee will get that sets out the possible things the Rules Committee might consider. I assume that Rick Marcus from Hastings, who's a reporter to the committee, wrote that memo. So it may be available from ACS or would be available on the Rules Committee website, and I commend that to you. And get in the way. I checked on StubHub just before I came. There were a couple of tickets still left for the Rules Committee meeting. They're going at a pretty high rate. Not up there Super Bowl yet, but But I listen to everything John Lewis says, and he tells me to get in the way, I'm going to get in the way. He's way better than I am. He's smarter than I am at that stuff.
And you missed that, well, we alluded to it, but Congress is also actively considering the legislation. There's been hearings and testimony to essentially roll back the clock to Iqbal and Twombly, and then let the Rules Committee decide. Because one of the things, if the Rules Committee takes a lot of time, who should bear the burden of that time? And it would seem to us, or me at least, that the vulnerable civil rights plaintiff should be protected, and we should revert to the status quo. And then if people want to study and want to tinker, fine, but let's not tinker in this uncharted world where all the evidence points to significant concerns about access to justice.
I'm going to open the floor up now, but right before I do, I want to give the panel an opportunity, if there's anything that of great importance that we missed that you want to talk about right now before I open the floor up.
I just want to reinforce one thing for the students. John Lewis talked about how important lawyers are and loving lawyers. Judge Bryant was the first African-American judge on the bench in the D.C. district, and just before he passed, he was interviewed and said, a woman asked him, "What do you think of lawyers?" And Judge Bryant said, "I love lawyers." He said, "If it weren't for lawyers, I'd still be 3/5 of a man."
Yes. Any more questions?
Yes, my name is Ernest Marshall. I'm chief of the Black Creek Muskogee Nation and a citizen ombudsman. I was going through some of your documents, and most of your documents talk about Title VII or Title V. But as Adam Clayton Powell once told me, the 1964 Civil Rights Act would deal with if you really want to do something. I'm from Georgia, by the way. I lived under Jim Crow, lived in segregation 21 years. The only way you stop it is you hit the man in the pocket. Title VI of the 1964 Civil Rights Act that deal with federal funded projects. I see that a lot of cities, counties, local municipalities, congressmen, and everybody else don't understand Title VI that deal with federal funded projects. Title VI said to prevent discrimination. Now, a lot of your law schools don't even teach Title VI. I found out that even the state of Georgia Attorney General's office don't deal with Title VI of the 1964 Civil Rights Act that deal with federal funded projects. That means if I'm a contractor and I've been discriminated against, if I go to the Justice Department and I get that 95-page document that they have, and I follow that 95-page document and file through the that committee, then the United States is supposed to represent me as a plaintiff, but that's not happening. Even if I go pro se litigant, and I take it to federal court, I would get so far in federal court that the judges themselves would not even react on it. What do you think has to be done to deal with the Jim Crow laws that still exist, and that Title VI of the 1964 Civil Rights Act that deal with federal funded projects? How would you deal with that as an attorney?
Title VI is a very powerful tool that LDF, where I work, has used historically. The problem and the subject of probably a whole nother panel is a case called Sandoval, which constrained the ability of private plaintiffs to bring disparate impact suits under Title VI. Interestingly, the Justice Department on the Iqbal Twombly issues that we're talking about here is a little schizophrenic. The Civil Rights Division is trying to survive motions to dismiss of their complaints under Iqbal, and in fact had a big predatory lending case dismissed under Iqbal and is appealing that to the Ninth Circuit. But the Civil Division, which defends the government, is reading Iqbal and Twombly for all they're worth. Argued Iqbal for Ashcroft in the Supreme Court, but even in this administration continues to assert a very broad reading of that, which is quite concerning. So there's advocacy to be done vis-a-vis the federal government to not only step up and enforce Title VI, as you mentioned, but also to recognize that the importance of private attorneys general in supplementing federal enforcement and their own enforcement is critical to these access to court issues.
I'll give you an example from a case of how the government's done that. My favorite example was a guy made a lot of allegations that he was under surveillance by the Department of Homeland Security. And one of the allegations was that there was a bug, a tracking device on his car. And the Justice Department said, well, he didn't plead that that was our tracking device. He didn't say that it had our markings on it. Now, I'm no spook, but I'm figuring they put a tracking device on the car. It doesn't have a little Department of Homeland Security seal with a note that says, if found, please drop into any mailbox, right? I don't think so.
I would like to continue these questioning, but we are now gone over our time, and I'm going to conclude, though, Suzette has a poem dealing with this. So. Thought it'd be fun for
Okay, well, you could read the law review article, but if you don't read the law review article or if you don't read the issue brief, I'm also kind of a Dr. Seuss. I can do Dr. Seuss for you. This is a perfect example of somebody who's been thinking about this issue for way too long, right? I did this last year, and it's all that was on my mind. At Catholic University, we have a nice tradition where every Christmas we get together and we have the opportunity to share poems, and a lot of people will write their own stuff. And so I whipped this up that morning because all I really could think about was Iqbal and pre-dismissal discovery. This was what was in my mind. So bear with me. I'll share this with you. This is called a Iqbal holiday poem. There once was a man named Iqbal who, after 9/11, got into some trouble. He and other Pakistani men were consequently thrown into the pen. He was put in maximum security 23 hours a day. His treatment was unfair, he was heard to say. A.G. Ashcroft and Robert Mueller were allegedly to blame. Iqbal contended if he wasn't Muslim, he wouldn't be treated the same. Iqbal went to jail to serve his time, but he also took his case to the 9. The Supremes took one look at his complaint and said, a factually clear cause of action, it ain't. Formulaic recitations, so many conclusory allegations. Back in the day, this complaint would work. In discovery there, the facts would lurk. But after Twombly and Iqbal, it's a different day, Justice Kennedy was heard to say. The pleading standard has changed. We don't accept plaintiffs who are deranged. You have to have facts. Your claims must be plausible. You can't get discovery if your allegations are bold. Under Rule 8A2 and 12B6, plaintiffs will now take some licks. Judicial experience and common sense tell the court what to do, resulting in civil rights cases, now just a few. This doesn't seem fair. This doesn't seem right. After the last 50 years, doesn't the court not care? Granted, the plaintiffs are doing their best, but everyone seems to think they're a pest. We need some discovery. How can we read people's minds? Would you say out loud that you don't like my kind? Discrimination is subtle. It's so underground. If I had some discovery, the evidence would mound. Oh, it's a post-racial society, haven't you heard? There's no more of that. Your theory's absurd. Your fishing expeditions must come to an end. To greedy plaintiffs, a strong message the court must send. Your frivolous lawsuits force defendants to settle. In the lives of our leaders, you continue to meddle. After half a century, it is time for a change. Plausibility is the standard. We are tightening the reins. What a big problem. What should we do? Enact a bill? Threaten to sue? No, this is far bigger. It's time for a law review. Yes, an article is what's called for these days. It may get criticism, it may get praise, but someone must solve this problem for sure. Civil rights plaintiffs can no longer endure. Here's an idea, so simple yet profound. Let the plaintiffs get discovery before the death knell sounds. Don't rule on that 12b6 motion too quick. Maybe a little discovery will make the plausibility stick. The courts have done this a time or two before. Qualified immunity, jurisdiction, class certification, and more. Let's try it here. Let's give it a shot. Plausibility discovery could become really hot. No time to do this, no desire to bend, but without some risk, civil rights could end. One law professor is pushing this hard. This new idea she has, she must carefully guard. Her friends are at Christmas parties having a ball. It's the holiday season, you should be at the mall. No, no, this isn't the time for that at all. I must solve the problem I call Iqbal.
Thanking our panel. Great point.